Hi there, Nicholas Campion here with the latest installment in the First Formations video series. Over the next few minutes, we're going to walk you through the basics of what is a company shareholder, and that'll include their role in the company, the difference between a shareholder and other roles within the company, and what shareholder information is available to view on the public profile. Now, shareholders are also known as members, and they are the owners of companies limited by shares. And they can be an individual person, a group of people, a partnership, or another company, or any other kind of organization or corporate entity. To be a shareholder, a person needs to take at least one share in the company. And the number and value of the shares will determine their total ownership in the company, which will in turn decide the decision-making power, the profit entitlement, and the extent of personal liability. As the beneficial owners of a limited company, shareholders aren't involved in the day-to-day management of the business. These duties are instead the preserve of the directors, although shareholders do have the ultimate authority and they can appoint themselves as directors. This means that you can set up a limited company on your own by taking shares and appointing yourself as a director. Let's take a closer look at what the role of a company shareholder is. Typically, this will involve investing money in the business, receiving portions of the company's profits in relation to the shareholdings, contributing to the company's debts up to the limit of their liability, deciding which powers to grant the directors, making decisions in exceptional circumstances, for example, changing the name, structure, or indeed altering the articles. And the role also involves setting directors' salaries, authorizing dividend structures, and receiving a portion of surplus capital if and when the company is wound up. So that's the usual role of the shareholder. Now, when you go through the formation process, you may have seen reference to the shareholders as subscribers. Let's take a moment just to look at what is the difference between a shareholder and a subscriber. Now, essentially, a subscriber is the term applied to the first members, that's either the shareholders or guarantors, of a company. We'll get on to what a guarantor is in just a moment. Subscribers are the individuals that add their name to the Memorandum of Association during the company formation process. And by doing so, they agree to form the company and become a part of it. The names are also added to the Public Companies House Register, and it will remain there even if they leave the company at a later date. There is nothing else that separates a subscriber from a shareholder with respect to their position in the company. Any person or corporate body that becomes a shareholder after the incorporation of the company is not a subscriber. They are simply referred to as a shareholder, member, or owner. As a side note, regardless of whether a shareholder becomes a member during or after incorporation, they may also be a person of significant control. So that's the difference between a shareholder and a subscriber. Now let's take a brief look at the difference between a company shareholder and a guarantor. Now, shareholders are the owners of a company limited by shares. Guarantors are the owners of companies limited by guarantee. Both are referred to as members, and both may also be PSCs of the company. Shareholders are responsible for contributing toward the company up to the nominal value of their shares, whilst guarantors agree to pay a fixed sum of money toward the company's debts. That's their guarantee. Shareholders also will usually receive a percentage of profits in relation to the number and value of their shares. Companies limited by guarantees do not have shares. They are normally set up as non-profit organizations, which means guarantors can't usually take any of the company profits for themselves. Indeed, in a lot of guarantee companies, there are actually provisions within the article that prohibit any of the profit being passed over to the guarantors. Finally, let's talk about the difference between a company shareholder and a director. Now, these two roles are entirely separate and different from one another. A shareholder is the beneficial owner. They provide the financial security of the business, receiving profit and having ultimate control. By contrast, a company director is appointed to manage the day-to-day operations and finances on behalf of the company shareholders and for their benefit. Now, you might be asking yourself, can a shareholder also be a director? And the answer is yes. The same person can be a company shareholder and director at the same time, which means you can own and manage a company by yourself by being a sole director and member, or you can own and manage a company with other individuals by being one of two or more owners and directors, or you can own a business and appoint someone else to act as director. There is no legal limit to the number of shareholders or directors a company can have, so you have the option of bringing in more business partners or more directors later down the line. A person who wants to be a director needs to be at least 16 years old, and they can't be an undischarged bankrupt or a disqualified director. Now, another question you might have is how many shareholders are required to register a limited company? Now, here in the UK, you need a minimum of 1 shareholder to register a company. There is no upper statutory limit to the number of members a company can have during or after incorporation. It's also important to bear in mind that some shareholder information is available on the public record. These details are registered at Companies House and will include information like the full name of the shareholder, the service address if they're a subscriber or also a PSE, the types of shares held, the number of shares held within each class, the nominal value and currency of those shares, and the amount paid or due to be paid on each of the shares in question. If a shareholder is also a person of significant control, they'll have to provide some additional information to go on the public record. That will include their date of birth, their nationality, and their country of residence and nature and control over the company. PSE is a topic in its own right, and we'll look at it in more detail in a later video. It's important to remember that all of these details will be held and displayed on the public record even after shareholders depart the company. Directors will also need to record this information on the company's register of members, as well as register of PSEs if applicable. These registers must be kept at the registered office or sale address if they have one. Statutory registers can be inspected by members of the public, so they must be kept up to date at all times. Finally, let's talk about corporate shareholders. Now, a corporate shareholder is simply a shareholder that is a non-human entity. In other words, it is itself another company or partnership or organization. The role and benefits of being a corporate shareholder are exactly the same as a natural shareholder, although the corporate shareholder must appoint an authorized person to act on its behalf. And this individual will represent the corporate shareholder's interests, exercise their voting rights, and sign any required paperwork. And that's it. So today we've looked at the role of the company shareholder, the difference between a shareholder and other company roles, and what information about shareholders is available to the public. If you have any questions, please leave a comment. We're always happy to help, and we can't wait to hear from you. Don't forget, please like this video and subscribe to our channel to receive more videos just like this. We'll see you next time. Cheerio.